Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Good morning. We are on the record in the matter of Charnethia Mitchell versus Landings at Chandler Crossing. This is case 23-02184 GC. May I have appearances for the record, please? Ms. Mitchell first, as it's her case.
Hi, I'm Charnethia Mitchell.
Thank you. And, sir?
Good morning, Tyrone Fleeman on behalf of the defendant.
Thank you. So we are here for two matters. We are here for a pretrial conference and also a motion for summary disposition. Maybe more efficient to take up the motion for summary disposition first. Mr. Fleeman, your motion, sir?
Good morning. Has Your Honor had an opportunity to read the motion yet? Only because it's fairly lengthy.
Yeah. Fantabulous. I'm not. There were duplicate my files. So could you, would you be so kind as to bring the court up to speed?
I can.
This is embarrassing, but thank you.
That's okay. And
no, I should have known it was in the file.
And you said duplicate my files?
There is one my file that doesn't contain anything after October 31st, and there is one that contains matters filed into this year, including February and March. And they are separate within our system.
Are all courts like that, or did you guys just get the lucky straw that you got two MyFile accounts?
No, we have one MyFile account. I have no idea how this happens. And it's an embarrassment, and I'm sorry about that.
No, that's
an absolute embarrassment. But
well, Your Honor, then I will start at the top. Essentially, Ms. Mitchell's claim is that there was some error made in the accounting when she first moved in, where she paid a couple of payments totaling $1,340. And I explained in the motion that according to the lease, the tenant is supposed to make the whole lease is broken up into one lump sum of $8,040. And this is something that's a little unusual about this lease. This lease is a term lease versus a month-to-month lease or anything like that. And when I say a term, I mean a fixed term, in that the way they build their whole model is that everybody moves in at the same time and everybody moves out at the same time. So they have this mass move in and then this mass move out that is typically tied to the school calendar, right? It's built around I call it the dormitory business model. It's not really a dorm, but they're doing the same thing. And so what happened in this case is Ms. Mitchell showed up and applied for an apartment on, I think, the 28th of August, which was just the day that everybody was moving in at the mass move-in. So she applied way later. Most of the tenants in these buildings, all three of them, apply either when they move out the year before or sometime during the summer. In Ms. Mitchell's case, I don't know for what reason, she just happened to show up at the very last second and applied on that date. So the lease is built to call for an initial installment of $670 and then an initial installment when you sign the contract, and then another installment on August 28th at the beginning of the term. In her case, they were both due at the same time because she was so close in time. So the $1,340 that she paid, and you can see this on the ledger, which is Exhibit D, was properly applied to her first two installments of $670. So that was one of the things that I think was just kind of a misunderstanding that she had as to the accounting. She also was of the belief that she had executed a self-guarantee addendum. That would be Exhibit B to the motion, and that addendum calls for a payment of $1,005, which is 1.5 rental installments. This is in lieu of a security deposit, or if people do not have a guarantor, they do the self-guarantee addendum where they pay 1.5 months worth of rent. And I see the addendum in the file. I don't know that there's a signature line on it, so I don't know that it was ever actually signed. Be that as it may, I've submitted an affidavit of Isaiah, who is also here today, indicating that despite his best efforts, he could not find any evidence that that $1,005 was ever paid. And as you may recall, that this case has gone on a while. Ms. Mitchell and I have had kind of an informal discovery wherein my initial approach to all of these cases, Judge, is, these are questions of math. So if there's some credit that's due, there's credit that's due, I'll get it straightened out, right? So I was looking for some evidence or a check or whatever, but have never to this day received anything. So I don't believe that $1,005 was ever paid. As such, I believe the accounting on the ledger, again, Exhibit D, is appropriate. We went from that to where to go with that next one. Judge, I had a piece of paper and now I have lost it.
No one understands better than me today.
Boy, we're just gonna fire off on a Monday right away. Well, okay. Come back to the motion then.
Actually, this is not a particularly long motion. I mean, it's 5 pages. Thank you. You had me scared there for a minute.
I did my best. It's just the number of exhibits that I have to use to kind of show it. And part of the problem that I have in this case is that we're trying to pull information from quite a while ago, and management people have changed, and so I'm recreating a lot out of a bunch of exhibits. But it all does kind of spell out. The next thing that I think she brought up was, oh no, back to this applying at the busiest time of the year. Let's talk about that, because she applied on or signed her lease on the 28th, which is the beginning of the lease term. They got her a key fob on September 2nd, and I attached an Exhibit H that shows, and that's something from their tenant communication system, and that shows that the key fob and clicker and everything was given to her on the 2nd. I also attached an Exhibit G, which is an email communication or a note of a communication indicating that Ms. Mitchell had called in. That was dated August 28th, and the representative, Jacob Stinson, called her back and indicated that she can't move in until the 1st because she signed the lease 10 minutes before that communication. So there was, I know, some communication about the fact that a place wouldn't be ready. I have to rely on common sense to say that there's no way she would have applied during this early part of the move-in and not have somebody say to her, hey, this is really busy, we're moving in all, and I'd have to ask Isaiah, I don't know how many units they have there, but it's a lot of bed spaces, and they rent by the bedroom, and so it's quite an ordeal. So I think that the delay in her getting moved in was probably baked into the initial communication simply because of the timing of when she would have applied. And that being said, also they structure this as a term lease where you're renting this block of time. You're not buying a month of time. So the fact that there was a couple days delay, she still got this term just a couple days later than what she would have if she would have applied a month or two earlier, let's say. So that's what's going. That's what I have on that one. But there is no dispute that she did sign it on the 28th and didn't move in until the 2nd of September. That's from what I can tell. Next, she goes on to argue for credit of an $82 Michigan Energy draft that she alleges was collected by the Landings. again, referring to the affidavit of Isaiah, I don't see, he cannot find, rather, any evidence that that $82 was ever applied or that it was ever actually received. I see communications where she spoke about it, but I don't see where it ever hit this ledger. And like the other items, I asked Ms. Mitchell from the very beginning, send me a copy of anything you have showing that it was actually paid by them or that it was actually received. But to this date, I don't have anything showing that they actually received that $82 Michigan energy draft. Then next she goes on to argue that she incurred excessive utility bills, the product of a portable air conditioner whilst her air conditioner was being repaired. I asked for information on that. I never received anything showing a spike in utility bills, so went out and did some of my own research on that, and I'll get to that in just a minute. But I also don't have any evidence from the defendant or from common sense that a portable air conditioner draws massive amounts more energy than a built-in air conditioner does. So if she were running her built-in air conditioner for those same 4 days, I'm not sure there'd be a big energy difference between the two. And when you go to Exhibit E, this is something I pulled out of the Excel spreadsheet of her ledger and put together all of the utility charges, and you can kind of pace it along. When you get to the very bottom, you'll see two that are $114.94 and one that's $199.23. That's because of the last 2 months. If you look at the dates, that covers from May 11th all the way through July 31. So that's it all comes on a final bill, because utilities are always billed in arrears. They're always billed retroactively.
Right.
So the final bill comes, and it always surprises people, and I think it surprised Ms. Mitchell. That final bill is much larger than normal because it was 2 bills. Now you can see, if you look at the kind of the range of prices, it did spike for those 2 months for sure, but those were also the hottest 2 months of the year. And if you go back to like September of the year prior, it was $91.80 for that period. So May to June was $114. So I'm not able to, from this, pick out any particular spike in utilities, though I can tell from looking at the records that she was her built-in air conditioner was reported broken on June 25th and was repaired on June 29. And for the record, Your Honor, that would be Exhibit I that I have that one on, that maintenance record. And then I also attached a final account statement, and that would be item C through C2. And that was provided for illustration as to what amounts were owing when she moved out. And that exhibit reflects a balance of $450.61. Of that amount,
And I'm sorry, this is Exhibit I you're discussing?
sorry, nope, Exhibit I was the maintenance record for the call-in of the air conditioner.
Okay.
Exhibit C and C1 and C2 are what I'm talking about relative to the move-out checklist, basically showing that she owed $450.61. Well, the first 2 items on there are those final electric bills that I'm talking about. And then there's also 2 gas bills for $44.65 and $24.43, and then $56.36 worth of rent. That's all on Exhibit C1. And so because those amounts weren't paid, because she moved out owing some amount for utilities and some amount for rent, I don't think she has standing to make any of the claims that she is making today. These are not monies that she actually paid. And so I think lacks standing. I also think, and I didn't really ever think I'd be making an argument for latches, I think this is probably where latches really does actually apply. She's speaking of things that happened at the very beginning of her lease, which is August of 2022, and we're talking about them in April of 2024. she lived there for an entire year or 11 months and could have either brought these issues up and resolved them with management at the time when the managers that were there are the same ones that are there now. They're not. Back then, she could have discussed it with the managers in charge at the time and could have abated her rent if, in fact, the student portal was showing that she owed, a full installment and she felt that she was entitled to a couple of days off. She could have brought that up with management then, and it could have been handled with people that had personal knowledge of what was going on, specifically like that conversation I discussed when she first moved in. They would have known what was the substance of that conversation and could have actually resolved this, but that was not done. So I think that for the reason of both latches and standing, I think she does not have a case, and I think the motion asks that the court dismiss the claim with prejudice. I will say also on the affidavit of Isaiah, which is Exhibit F, is indication that she did have access to her student portal, which is the accounting method for this, at times during her tenancy. And you can see on this portal when students actually get into it. So we know that she was actually using that student portal. So these dollar amounts were not a surprise to her when she moved out. These dollar amounts were always on that portal. And I think
Ms. Mitchell, I'm not sure what you're saying, but
that's all I have on it, Your Honor.
okay, thank you. Ms. Mitchell, would you like to respond?
Okay, first I want to start off by saying I calculated like the last 2 or 3 months before I was supposed to move out. I seen how much money I had left on the SARA program, and I calculated how much rent and insurance would have been, and I still should have had probably a little bit of money left over from the SARA program. So I wasn't checking my resident portal every so often because my bills were getting paid automatically. I do have proof about that energy draft bill. It's a video. I just don't know how I'm supposed to send it in to show you guys that the landings did receive it and they never returned it back to me.
A video of what, if I may ask? I mean, what?
Of me handing them the energy draft bill.
This just this energy draft, is this like a tax credit or what? I'm not familiar. There are a couple of varieties. I'm not familiar with all of them.
It was sent to me from the state of Michigan, and it was supposed to be towards any energy draft bill all the way up until December 31st of, I believe, 2022. And also the money orders, I tried to get those tracked down, but I don't know, for some reason I haven't been able to hear back from the Western Union, and I don't know how else to contact them. But there's still $500 that is missing, that went missing in January, that I did not know about until after I received my ledger, and I looked through my money orders, and I looked at how the money orders that I got to pay my rent, because that's the only time I use money orders. And then I looked at my ledger to see, when I stopped paying rent. And then I seen that in January, $500 just disappeared. It was not added to my account, but I had the money order to prove that I paid my rent with that. Yeah. Also, I know I didn't gain access until September 2nd. And look, okay, if it's okay with you guys, I have someone that I would like to represent me.
No.
And no?
Unless is this person an attorney?
Okay, well, I don't know what else.
The rules of court are specific. that to represent someone else in court, you must be an attorney.
Okay, I understand that. But all I'm saying is there's still $500 that is gone missing that the landings is responsible for. I was pregnant during this whole time, so I could not, like, I wasn't worried about, the money, and I didn't even know that I was missing money until after my pregnancy, after I gave birth and everything. That's when I looked back and it was like, why do I have $400 and whatever saying that I still owe money to the landings? What?
Before you gained access.
Because it's a term lease. And like, I understand that. Well, I don't understand. For the lease, I was supposed to pay, like, the lease is an agreement, a binding agreement, right? So the lease says that I'm supposed to pay $1,005 upon move-in, but I paid $1,340. I understand that it was put towards other places, but like from the beginning, the lease was just, it wasn't honored on the landing side because they didn't put the money
But
where it was supposed to.
I'm sorry, the person who is talking in the background, I appreciate that they're trying to help you, but it's making it hard for us to hear. And also, most importantly, it's making it hard for the court to make a recording because there's a certain other amount of sound in the background. So if just you could speak, that would be helpful. So if you could help me, so January of 23, you said was the $500 money order?
January 22, that's when because I had to pay rent twice that month. I already talked to Bailey about why I have to pay rent later in December.
Okay.
So yes, in
Your Honor,
January, that is where.
Just let's let Ms. Mitchell finish first, and then please go ahead.
Okay, and I just pulled up the email, January of 22. This is where, like, I'm asking about the money. Oh, wait, not that one. And Olivia, I know she doesn't work there anymore, but she told me that she knew that I am a self-guarantor, and like I don't know why he said that I didn't sign the lease or whatever saying that I would be a self-guarantor, because before I got my keys, that's what I had to do.
Okay. Well, let's see what we've got here. So Mr. Fleeman, I think about the date. I believe that would have to be January of 2023 if you moved in August of 22. Mr. Fleeman?
Judge, no, that's why I was going to jump in. I misspoke. She moved in August of 21. I misspoke when I glanced over at the lease and I saw 22. That was the move out date was 22. The
Move out
was 21. So I set you on the wrong path by saying August of 21. So she is right about January 22. But when I look at the Exhibit D, page number 5, and also page 6, I see payments that were made on the bottom of page 5. I see a January 6th payment of $500, and then another payment of $49.82 on January 18th. Also on January 18th, I see 2 more payments of $500. So at that point, had her balance down to $75. So I'm not, and this is the first I've heard of the missing $500, or at least that wasn't in the written answer anyway. So I didn't address that in my motion, but I do see payments of $500. on the ledger. Obviously, Ms. Mitchell is the plaintiff. The burden would be upon her to prove that she made a payment that was not received. And as I said in the beginning, if she had shown me a payment that she didn't get credit for and that we had cashed it, I would have told my client to issue her a check. That's just very simple. Or at least offset the $450.61 that she owes for the utilities and stuff. So I don't know what's going on with the $500 relative to the video proof or the other emails, whatever. Ms. Mitchell did not file a written response to my motion, so I don't have any documentary evidence that she would be speaking of. More importantly, she's not submitted any affidavit of facts setting forth that there is, in fact, a meritorious claim here. I think that under C10, plaintiff is entitled to summary disposition.
So, Ms. Mitchell, did you receive a bunch of documents, all of these exhibits from Mr. Fleeman?
Yes.
Okay. Do you have them in front of you?
No.
Did you review them? Did you read them?
No, I did not read all of it, no.
Okay. Did you submit any documents to Mr. Fleeman or to the court?
Yes, I believe I sent over my money orders, the emails, my ledger that I have, the copy of the lease that I have.
Okay.
I
Were
did
those
it,
sent to Mr. Fleeman?
yes, I did it through M-File.
Your Honor, I received the money orders with her initial complaint, or soon after, the money orders adding up to $1,340. It was like 4 different orders or 5 orders, I think. And so I did receive those. I've not received the $500 one that she's talking about that is missing. I would say that my experience in real estate or landlord cases is we can't track down that money order anyways. The person who purchased it is the only one who can go to the issuer, Western Union or whomever, and have it tracked down. And I'm positive I said to Ms. Mitchell the first time we met, because I say it all the time, track that down. Get me a copy of the back of that so I can use the stamp that's on the back of it to track down where it went in their system. And so yeah, if she would have provided that, I certainly would have done the research, track it down.
I don't believe you told me to do that. I tracked it down myself, but I have not heard back from the Western Union. That is not my fault.
Okay. Well, when did you reach out to Western Union?
This was a couple of months ago, maybe 3-4 months ago.
Okay. Well,
they were supposed to get back to me in 30 days.
Okay. Well, because you are the plaintiff, because you're the person bringing the lawsuit, you have the burden of proof. In other words, it's your job to make sure that all the documents for your case are there and available to the court, and also to the defendant, to the person who has to defend themselves. And the defendant, anything that they want to use as evidence, they must also provide to you. Because this case has been pending for several months, and because we really don't have sufficient proof of the allegations, I am going to dismiss this case on the merits. And
what can I do to get you to not dismiss this case? Because I have the proof. Like,
well,
what? I don't know.
Ms. Mitchell, we've been here since October, right? So we've been at this for 6 months. And in prior cases, I believe I've told you that, but first, I can't give you legal advice, but there are things that you have to do when you bring a suit, which is to prove, well, you have to prove an obligation and damages. So you haven't proven that you've had damages. You haven't provided evidence of that to the court or to the defendant. And if the situation were reversed, if Mr. Fleeman were suing you, if the Landings are suing you, they would have to prove that you had an obligation to do something, you didn't do it, and that resulted in damages. So if they, for instance, were suing you for some money, they would have to show that you owed the money, that you didn't pay it, and that they had a loss. In this case, you're asking for money from the Landings. So as the plaintiff, I think the plaintiff is the person who brings the complaint. You have to show that they had an obligation to you, they didn't do it, and you're out certain monies. So I don't find, rather, I find a matter of, find for the defendant in summary disposition, meaning that I don't believe that there are, we haven't seen evidence provided to the court that a case can be made or sustained. So,
Okay, can I refile?
well, generally we dismiss cases what we call as without prejudice, allowing people, well, actually, no, because this would be an adjudication on the merits. You know, to be an adjudication on the merits, meaning this matter is decided. There may be an appeal process. You probably want to speak with an attorney because appeals are even more structured. I think I've told you before that people think we go to law school to learn how to talk. And what we actually learn how to do is move the pieces around the Monopoly board. We learn the various rules of the game and what has to be filed when and how you build a case. So if you want to appeal, you would have a right to appeal. However, I highly recommend that you get an attorney because the appellate rules are even more structured. There's even less room. You originally filed as a small claims case, which is almost more of a negotiation. Then, because the person you were suing wanted to elevate it to a full court case with the rules of the court, if one party wants to do that, then that happens. So now we're here. If you want to appeal, it will go up another level, but the rules become even more structured. Mr. Fleeman?
Your Honor, I was just going to indicate that I did submit an order with the motion for summary disposition for your signature. And I was going to ask if you wanted me to send in an order, but then I realized I had already submitted one. And so, yeah, that's it.
Okay. And are you seeking attorney costs and fees?
I am. I did not make a specific request for that, but for sure I have invested an enormous amount of time into this because we have been here a number of times. I would, I would appreciate some award of attorney's fees. I don't know how the court normally wants to handle those.
Can I, because like I know we still had a court date for the 13th at 9:30. What if I had an attorney by then?
I'm sorry, I'm going to rule for summary disposition.
And Your Honor,
So,
costs and fees.
So what we will do is have a hearing on costs and fees at that time. Okay, so Mr. Fleeman, if you want to submit a motion with proposed costs and fees, the court will decide.
Motion on what do we have? May 13 is that?
Let me
I think
let me scowl at the screen again and see if that's
I just,
just a moment, please, Ms. Mitchell.
Your Honor, it's scheduled for May 13th at 9:30.
Okay.
Okay. And so I would need to submit a motion for costs and fees by that time, right? Or,
Yes, sir.
Okay.
And of course, provide to Ms. Mitchell.
Oh, absolutely, yes. Yeah. Okay.
I don't know what's going on.
Okay, so Ms. Mitchell, I'm dismissing your lawsuit. What comes up next is Attorney Fleeman has asked the court to have you pay his costs and fees for the lawsuit, which is something that happens in civil suits. The court has
Are
not
you
decided.
sure?
Excuse me, please don't interrupt. So the court has not decided whether he will be granted those costs and fees. If he's granted those costs and fees, they have to be reasonable. They have to meet certain standards. My best advice at this point would be to go to either seek an attorney or go to mylegalhelp.org. It's a website, mylegalhelp.org, and it can guide you through these things. There are also non-attorney staffers who will answer questions, okay, about what can and can't be in legal fees, perhaps about rights to appeal. So we will be back at May 15th at 9:30 a.m. on May 15th, and we will take up costs and fees. However, this case is dismissed on the merits.
Your Honor,
Anything? Yes, sir.
May 13.
13. Thank you.
May 13 at 9:30.
Thank you. And Ms. Mitchell, I misspoke. May 13. So we'll be back at 9:30 a.m. May 13. Ms. Mitchell, is there anything else you would like to say?
No.
Okay, so we will be back then. This case is dismissed on the merits. That is all for this record. Thank you.
Thank you, Your Honor. Have a good day.
Thank you.